Why do you look so depressed?
Have you ever thought about how many trees we have to cut down to produce enough paper for one day at the office? It is horrible. We should save these trees.
No. We have these things called tree farms. The trees are grown for us to cut down. It's not horrible, it's the circle of life.
I love trees. How could you not love trees? I love trees.
You're one of those hippie tree huggers, aren't you? I should have known by your outfit.
If loving nature and defending it makes me a tree hugger, then so be it. I protect the trees and nature. I will take it up with the Supreme Court if I have to.
That reminds me of a case where some hippies tried to do that. It was called Summers v. Earth Island Institute.
I remember the case. It was a sad day for nature lovers.
It was a great day for justice. Those environmental groups should have to pay money for tying up the courts with ridiculous issues. They had no standing. The environmental groups filed suit against the U.S. Forest Service alleging their regulations violated Forest Service Decision-Making and Appeals Reform Act.
The act was put in place to establish an administrative appeals process providing an opportunity for notice and comment. What they did to nature should be punished.
All this because of a salvage sale of timber on 238 acres of fire-damaged federal land. The regulation exempted small sales of this kind. Article 3 restricts it to redressing or preventing actual or imminently threatened injury to persons caused by violation of law.
The harm can be established through recreational interest and should be sufficient to establish the prerequisite for standing in this case.
That argument may have been better if Earth Island had not already voluntarily settled a portion of the lawsuit pertaining to any alleged members' interests before trial.
They should have still been able to file suit against the injustice of the regulation that limited the notice.
They failed to show any of its members planned to visit sites where the challenged regulations were being applied.
Additional affidavits purporting to establish standing were submitted.
They were submitted after judgment had already been entered and notice of appeal filed, and were thus untimely.
Standing should have been granted. It is an injustice.
That outfit is an injustice.